All right, everyone. Welcome back to class. This is going to be Unit 4, Representation and Labor. Or another way to think about it is hiring people. No matter what business we're working in, we're going to have to hire people or work with others. These people could be your employees. They could be a temporary relationship like an independent contractor. It might be things like you might have a talent agent, might have a booking agent. You might have a gallery representation. It's all about this idea of we have to have people represent us and we have to work with people. So what are the rules and what are the rules or the best practices? What guides us in those relationships? And like I talk a lot about in this class, how can we empower ourselves and make sure that we're taking full advantage of everything that's out there for us? So let me switch over to the website. Ooh, but before I switch over, this is only for people who will actually take my class. I set up a special Rito live cam. So every now and then we can just switch over and see my dog sleeping, just for a little bit of mental health. But let's go back to the course website. Okay, representation and labor. Like I said, the main focus will be professional relationships. Now, this differs from what we went over with business formation. Business formation is about how we form the ongoing business. So it's things that we were talking about, like partnerships, um, or it's the idea of ownership. We're not talking about ownership with this unit. We're talking about labor, people that work for us, people that represent us. It's different. These are relationships that can be ended and severed from you, but the business formation stays in effect. The structure does not change. So we're going to cover a few different things. We're going to start out with this kind of broadly with this idea of agency and representation, and it kind of helps us it places us within US law to kind of understand like what category of law kind of all these relationships operate under, and where we can actually find the rules and regulations to follow. Much like the way that contracts are governed by primarily contract law, um, agency is a block of business law that helps us define all of these different ways in which we are represented and how people can act on our behalf. So let's get started, and one second while I organize a little bit. Okay, so let's start first. Well, now I remember what I was going to say. Yes, we're going to go over agency and representation, kind of the broad concepts, and then we're going to drill down into the ideas of labor and employment, what it means to be an employer and what it means to have someone be your employee. And we're going to talk about how that is different from the concept of independent contracting and self-employment, and why that's such a key difference to understanding creative practices. This is one of the most common and important things that comes up in my discussions with students after they leave school and start to form their own businesses, work freelance, or go work for large major corporations or small businesses. Like all these things come into play. And this is an important part of the puzzle to understand to be a successful creative practitioner. So let's start out with agency and representation. So um, how are we going to define the legal concept of agency? Well, what I found from this site upcounsel.com is the definition of agency law deals with agent-principal relationship, and it's relationship where one party has the legal authority to act in place of another. Okay, this is the thing you're going to hear me say 1,000 times during this unit. This is the most important thing to understand about employees, about freelancers, about contracting people, about working with others. An agency relationship is where one person has the legal authority to act in place of another. This means that someone can go out and get into agreements, conduct business, or do things that are liable and fraud that you can be held liable for and fraudulent. And you know what? You are on the line because that person represents you legally. This is the thing to understand about agency. It could be minor. It could be you send someone out to make a purchase for you on your behalf, and you're on the line to make sure that you come through with the money for that purchase. It could be major. This is what a lawyer's relationship is. When people have lawyers, those are agent relationships. That lawyer is acting on their best behalf and representing them. but represents them in courts of law. So it's this idea of giving someone legal authority. That's where agency comes in. It's an important concept to understand because of this one idea. It's where one person has the authority to act in place of another. So agency guides us in a couple of different ways. There are some different essential questions that we need to answer. So for instance, does this person or company represent you? And to what extent do they represent you? We're going to talk about different levels of agency, but it's like, if you are a fine artist and you're working with a gallerist, that person represents you, hopefully, in terms of selling your work and promoting your work, but they do not represent you. Like, let's say that you get into a car accident and that person sues you. Your gallerist is not involved in that representation. If they are, it's a little kind of fucked up unless the person's a gallerist lawyer, which is rare, and we're not even going to go down that path. So the next thing we have to think about is, are they our employees or are they an independent contractor? This is important because there are completely different sets of laws and regulations, depending if you're an employee or an independent contractor. We're going to talk about labor and employment law, but agency law helps guide us in determining which one is which, or employment law more accurately, but the broad concept of agency helps us answer that. And then it's, do you represent this person? Are you the agent? Are they the principal? Do you represent them? Are you an employee or independent contractor? Is that twice? Oh, it's, are you an employee or independent contractor? Are they one? Are you one? It's understanding these relationships. This, am I an employee or independent contractor? This comes up a lot. I actually see this a lot with students. They'll tell me that they got into an independent contracting relationship, but then it turns out the person was treating them like an employee. And you know what? That's abusive. And they shouldn't have had to stand for that. How much power and control does this person or company have over you? Have over the work, have over you? What power can you exercise over others? What laws do you have to follow in order to have someone work for you? And do they have to follow those laws as well? And then also just like, how do you start these relationships? How long do they last? And then how can you end these relationships? All this stuff is pretty important. It's pretty major stuff in terms of hiring someone, working with someone, working under someone. So you can see why representation in labor is such a major unit in creative practices. You cannot really operate a creative practice on your own. You're gonna have to involve other people. And these are a lot of questions you're gonna have to answer along the way. So in terms of relationships, let's first talk about just like a business relationship. And that's really what I want to focus on with this this whole unit is like when I'm talking about relationships, I'm only talking about in the sense of business. You know, everything I talk about conducting business. For instance, I gave the example earlier of like, let's say you're in a car accident and you get sued and that lawsuit takes you to court. Like that's a personal matter. That is not going to fall under what we are talking about in this unit. I just want to talk about this in terms of business. We get outside of business, just get much more complicated and kind of outside of the scope of this class. So, but how we interact with people can be boiled down to one word: relationships. Once we know our relationship with someone, we can understand what powers we grant them. Furthermore, we can understand our responsibility to them. Here's some essential terminology that I'm going to use. I've already used some of this already, but I'm going to use over and over again throughout this unit. Fiduciary. When we talk about a fiduciary relationship, it's a legal or ethical relationship of trust. A person in a fiduciary relationship is obligated to act in the best interest of another. That's essential. If someone is your agent, if someone signs on to be your employee, or they are a freelancer working for you, or they are a lawyer representing you, or a talent agent, or a gallerist, so on and so forth, when they make decisions, they should be acting in your best interest. They are not your competitor. They are on your team. And being on someone's team is a fiduciary relationship. Different than, like, let's say a purely financial relationship. Like, let's say you're engaging someone in a straightforward sale. You're selling them a piece of work and they give you money for it. The transaction's over. That was not a fiduciary relationship. That was just a financial one. You were just making a sale. The trust thing was not important. Principal, you're going to hear me say this a lot. The principal is the party who authorizes another person to act on their behalf. Inversely, the person who acts on the behalf of a principal is an agent. So principal is the person that authorizes the other. Agent is the person that acts on behalf of that person. Yes, these can go back and forth. You can be simultaneously be principals and agents of each other. But in general, just remember, principal is the start. It's the person who authorizes. Agent is the one that acts on behalf of the principal. That's where that fiduciary relationship comes in. The agent has a fiduciary relationship with the principal. Third party, the only reason I bring this up is when talking about agency, I have to talk about the different groups. So a third party is any person or party outside of the two primary ones. So we have principal, which is the first party, agent, which is the second party. Third party are people outside of that general relationship. An employee, an independent contractor. I'm going to come back to this because we're going to define this in more detail as we move forward. But I think I covered this a little bit in one of the other units. Okay. Let's talk about oh yeah, because I talk about it right here. Let's talk about the agent relationship. So principal and agent, it's a party who conducts business on behalf of and in the interest of the principal. This is our starting point for agency. For any business relationship, the agent and principal should be clearly defined. You should know who is the principal, who's doing the authorizing. You should know who is the agent, who is acting on behalf of the principal. How this breaks down to be more specific in our lives as we get into the ideas of employer and employee. Easy way to know if you're an employee, an agent who works for a principal and whose methods and working conditions are controlled by the principal, entirely controlled. They're providing the equipment, they're providing the location, they tell you how and when you get paid. They have a complete and total control over your work. They own all the work that you produce. They own the process. Like all this stuff comes in. That is an employee relationship, which is very fundamentally different than an independent contractor. So this is a party who is contracted to do work with the principal, but whose methods and working conditions are not controlled by the principal. So here's an example. Let's say that you have a photographer, and the photographer needs to have a digital tech and needs to have a lighting assistant and needs to have hair and makeup on set to do this big fashion photo shoot. So let's say the hair and makeup people, they're not going to work with them all the time. So they hire them in as independent contractors and they pay them a flat fee, but the makeup people are expected to show up with their own like scissors and hair dryers and makeup pads and and the things that you open with the colors in them. And I obviously know nothing about makeup, but they're expected to come with the tools ready. The photographer isn't going to provide them. The independent contractor will. And then they discuss a flat rate. So there's just it's signing a check, here's how much you get for this job, which is different than say like the digital tech and the lighting assistant. Let's say that those are employees of the photographer. They get paid an hourly rate. And then the photographer has to do things like supply the computers and supply the lighting equipment. These people aren't expected to bring their own equipment. So you can see how even in that small example, independent contractors, they have to bring a little bit more to the table, but they have a little bit more freedom. Whereas an employee, you have to provide more for your employees, but you have a lot more control over what they do. So now these relationships can seem simple on the surface, but that's when we're only working with 2 or 3 parties. This can get more and more complicated as you start to layer more and more people into these situations. And this kind of goes back to what we were talking about with business structures. Why you want to have a business structure that best fits your form of business is because of things like this. Imagine being a sole proprietor, you're completely at risk, and you have 50, 60 people working for you. And you have to trust that all 50 or 60 people are working with your best interests in mind. It's kind of a precarious situation. It might be better to have them be employees of a corporation, like lifts some of the responsibility off of you. So this next part is just for my class, but I encourage anyone else watching this video to do this. I included a few different groups up here. I keep forgetting you can't actually see my mouse. Autonoton is a robotics and architectural design studio I've worked with. So Transmillennial, I can't even remember some of these examples. We walk through these one by one in class, but what I want you to do is Click through these and go to the YouTube videos and notice all of the people working to pull off these projects, and start to ask yourself, what are the relationships between these people? You know, I see the artist and I see an assistant, you know, and I see a construction worker and I see a planner and I see this and this and this. What are all of their relationships to each other? Are they independent contractors? Are they employees? Is it a temporary relationship? Is it ongoing? Who represents who in these discussions? Think with that lens as you look through these examples. Oh my God, Fire Festival. Fire Festival is the best one. Fire Festival is such a fuck up. We're gonna have so much fun in class talking about this. But think about that as you go through these examples and keep them in mind as we talk about things in this unit. So we've discussed what a business relationship is in general. It's someone acting on behalf, it's an agent acting on behalf of a principal. But we need to get a little bit more specific into what is the actual concept of agency and what defines an agent. So agency, consensual relationship created by contract or by law where one party, the principal, grants another party authority for another party, the agent, to act on behalf of and under control of the principal to deal with a third party. Remember, you're authorizing these people to deal with third parties. They're not being authorized to work with you. You're the first party. They're the second party. You get the idea. An agency relationship is fiduciary in nature. We talked about that. It's about building trust. And the actions and words of an agent exchanged with a third party bind the principal. Remember, the agent can get you into a legal agreement. They can make legal agreements on your behalf. You have to clearly define what these agents can and cannot do through an agreement. You know, you see it's in the first part of the definition. Consensual relationship created by a contract or by law. By law, we'll talk about it in a second, but in that contract, you want to say like, okay, this person is only allowed to do these things for me. Because if you can be responsible for what the agent does. When someone represents you, they represent you legally. It's important to remember. I'm going to say it probably way too many times. You're going to get really bored with me. So in general, like why do we even bother with this fucking agency stuff? So why is agency important? Enhancement. You can augment your creative practice utilizing the skills and knowledge of others. We are not our Da Vinci, Renaissance, whatever people. We can't do it all. We have to bring in other people to help. Agency is an important business concept that lets us do that. It helps us bring people in and enhance what we can do. Representation, you can empower someone to carry out your wishes who should have your best interests in mind. You can be in more than one. You can be in multiple places at once because you have your agents out there acting on your behalf. Employment. Understanding agency is an essential, I don't know why understanding is capitalized, is an essential aspect of being an employee or employer and knowing whether someone is an employee or independent contractor. You need to know these things because they relate to laws that we're going to cover coming up. But in order to employ someone and being employed by someone, it's good to know what your rights are and what their rights are. These rights were hard fought and won by labor activists, and they're actually still being fought for by labor activists. So it's important to know that these laws are out there to protect you, but if you're the employer, they're also there to make sure that you are following the right rules and protecting the people that work on your behalf. All right, common types of agents. A general agent. A general agent, they can do everything. They're authorized to conduct every type of business on behalf of the principal. This is like sole proprietor. This is the default starting point. You should not have a general agent. Let me just say that. You never want to have someone that's empowered to do just literally everything for you in business. It's not a great idea. You always want to have some level of restriction on them. You don't want to just give them carte blanche to do whatever they want. It's a bad idea. But in general, a general agent can generally do whatever. Which brings us to the next one, which is a special agent. Now, special agent is authorized to conduct only specific activities outlined in the contract. So like I was saying, I had to move out of the way so I could read my own sentence. There are rare cases when you want an agent to do everything. Most commonly, people are going to be some form of special agent. They're there to do something specific. I gave the example of a gallerist. A gallerist is there to represent and sell your work. Maybe you have a publicity agent whose only job is to handle your public relations and how you appear in the media or deal with media people to help promote your work. This is what I mean by a special agent. All it is that you are specifying the aspect of what they work on. And this is always taken care of in a contract. You want to have this spelled out. Oh, look, I say it right there. Spelled out in a contract. Get ahead of myself. Okay. I give some examples. I should really, I reread these every time before I record the lectures, and I always forget, and then I'm surprised. I'm like, oh, I actually put this down. So yeah, we have things like a talent agent, a gallery agent, a record company representative, a tour manager, a studio manager, a sales broker. You can connect these to the type of business you would have to do in your practice. These are the people you might need to bring on as agents to work on your behalf. Or you might do this for people. Okay, an agent with an interest. This doesn't just mean they like you. An agent with interest, it's someone who possesses interest so they own or control some aspect of the principal's business. It's an agent with some skin in the game. They will benefit personally from acting as an agent for your business. For example, if an agent representing an author's new book is also a contributing writer, their decision-making process will be affected more than if they had no ownership in the product. Sorry, misspoke. So let's say that, let's say it's a literary agent and they're trying to sell this, they're trying to sell an anthology, but they are in the anthology. They actually wrote one of the stories. They're probably going to be looking to do things that are going to make them the most money. Let's say you wanted to go with a certain, publishing company because let's say that it is majority minority owned, and you're like, well, I want to support minority owned businesses and I want to go with this publishing company. But your literary agent, who should be acting on your behalf, wants to go with a different agency that's led by like all old white men, because that agency is going to be able to guarantee a bigger payout, which means more money for them. So the thing about agents with interest is that you just want to be aware what their interest is. If they have some ownership in the product, it's like they're both an owner and they're an agent. It affects how they make decision making and how they view that fiduciary relationship with you. So it's something to keep in mind. You don't always have agents with interest, but let's think of another example. Another example would be like, say you're working with a gallery and they're selling some of your work and they have a very high commission percentage. They're going to get a lot of money off any sale. They're going to push sales in a different way than if they're acting just purely on your behalf. You might be trying to get a work into a particular person's collection, whereas like they want to do a really high number sale because it's going to increase the percentage of money they make off that piece. That is the idea of an interest, versus if you just paid someone a flat rate to work for you. It has nothing to do with how much they do or do not sell. That person's decision making will be different. These can be positive too. A lot of times commission rates are used to motivate people who do sales. So it's not all negative. It's just be aware that there's more than one thing at play with an agent with interest. Okay, and a sub-agent. Why didn't my GIF work? It's very upsetting. All right. Well, a secondary agent who is representing both the primary agent and the principal. So I'm just going to jump into the examples because it really helps get this concept across much quicker. Let's say that you are a general contractor. I'm sorry, not you are. Let's say that you own a house and you hire a general contractor to do some construction on your house. And that general contractor gets a plumber. The plumber is an agent of the contractor. The contractor is your agent. So the plumber to you is a sub-agent. The plumber is working on your behalf to get the house proper plumbing. So they are working on your behalf, but they're working through the contractor. So they are a sub agent. So there's layers there. Another example is like, let's say that you have a, let's say that you're a collector and you have a particular piece of West African sculpture, and you were working with an appraiser to see how much it would sell on the market. That appraiser might bring in an expert in West African sculpture and pay that person to help appraise the piece. So the expert in West African sculpture is an agent of the appraiser who you might be paying to appraise the work. So the expert is the sub-agent of the appraiser is the agent of you. Let's say you're producing a movie and you hire a director, and the director goes out and hires a cinematographer. The cinematographer is acting on your behalf, but under the direction of the director. The semantics of creative practices makes my head hurt. But anyway, so what you want to do is with a sub-agent is remember that there's a relationship between the sub-agent and the agent, and there's a relationship between the agent and the principal. So those, for instance, someone could be your employee, but then they go out and contract the sub-agent. There's different levels of control there. There's two different relationships. That's the thing to remember with a sub-agent, is understanding those relationships and what powers those people are granted. So agency relationships are basically, it boils down to four main components: formation, control, authority, and liability. Why don't my GIFs work? Oh, this is so disappointing. Okay, formation. How do we start an agency relationship? How do we create it? You know, is it just appear out of thin air? Does it just magically manifest because, you know, I sacrificed a goat on an altar on like the midsummer's eve or the solstice? Solstice is a better time to sacrifice a goat, I think, anyway. Not that I would ever do that. So what are some different ways that we get agency relationships started? One is by agreement. This is the most common one. Both parties agree to a relationship by verbal or written agreement. That's it. We've already covered contracts. You know what a contract entails. This is the best way to do a relationship. It's by agreement. If you're being employed, you should have something you sign that says you're an employee. If you're an independent contractor, there should be a contract. It's in the name, independent contractor. There should be a contract. Written agreement is always best when defining these agency relationships. But there are other ways that an agency relationship can be established. So let's say by ratification, that's by a third party setting up the relationship, and then the agent and principal agree. So think of this like matchmaking. In the example I gave here, there's a lot of different examples of ratification, but one that's really simple and easy to understand is, let's say you're using the real estate website Zillow, that shows, this is for just like homes and apartments and condos and whatever, but you're on Zillow and you see a house and you really like it and you want to look at it, but you don't have a real estate agent. So Zillow's like, well, that's no problem. We can set you up with a real estate agent to go look at this house. So what they're doing is they're finding your real estate agent, and you're meeting with that agent to go look at the house. You know, the real estate agent might not be representing the house you're going to look at. They're just a real estate agent. You need them to be able to go view this house. And you don't know this agent ahead of time. Zillow has put you two together. And so you have agreed with the agent that the agent is going to be your representative so you can go inside this house and look at it. That's by ratification. The match was made and then you ratified it, said like, that sounds great, let's do it. By operation of law, these are agencies that are recognized by courts in the absence of a formal agreement. The easiest way to think of this is your parents or your guardians. So if you're under the age of 18, you're not allowed to enter into legal agreements on your own because you're considered a minor. Who does that for you? Your guardian. Why is it set up like that? That's by operation of law. So the law says, hey, you know what? For minors, it's their guardians. The parents or guardians are the ones that can make legal decisions for them. They are acting on your behalf. And the last one, the one I always hate to explain because I always screw it up, is by estoppel. So Estoppel means that a second party gives a third party, remember, a third party is separate from us. The second party, the agent, gives a third party the impression they are acting on behalf of the principal, even though no established agent-principal relation exists. I'm just going to read this definition I pulled off the internet. Agency by estoppel is considered a legally binding agency relationship. This means that an individual or company cannot unofficially give someone the appearance of working on their behalf, but then distance themselves from the consequences of the ostensible agent's actions. In other words, if a company supplies someone with office stationery, branded business cards, and an office in the building, in other words, giving them the appearance of being an official representative of the company, then they are liable for that person's action on behalf of the company, including any loans or insurance policies they have issued. Generally, it's like if you tell someone to go represent you, and then they get you in trouble and you're just like, well, we didn't actually have an agency relationship defined. I don't like, Mariah Carey gif, I don't know her. You can't really do that if you empowered the person with everything to seem like your agent and they thought you're acting as your agent. Like in the case of being taken to court, estoppel might come up. So that was formation. Our next aspect is control. So with control, it's what level of control does the principal have over the agent? What is the scope of work and duties for the agent? How much direction and control does the principal exercise over the agent's work? Can the principal determine the agent's working conditions? And this means, like, do they work in an office or they work offsite in their home? And is this relationship exclusive? So like, let's think about what's a good example? Let's just keep using a gallerist as an example. A gallery is representing multiple artists, not representing just you. So they are acting on behalf of multiple different principals at the same time. They've got a lot of interests at play. So that's what I mean by it's not an exclusive relationship. There are other things involved. So this is all about like what level of control you as the principal have over someone else, and to what degree. And that's kind of the idea with the scope and job duties. To what degree do you control them? Next, we have authority. This is a funky one because you think we would have covered this with control, but what is the agent empowered to do? How much authority can an agent operate under, or can operate with on the principal's behalf? So when we talked about control, that was about the power that the principal held. Authority is about the power that the agent holds. What can they do on your behalf? So there is actual authority, which is the principal assigns express or implied powers to the agent. And there's apparent authority, where the principal knowingly or mistakenly permits an agent to act. I should just scroll up instead of leaning over. To act with authority they were never expressly granted. This is again where estoppel comes in. This makes my head hurt, but essentially it's like, if someone's going to represent you, make it very clear what they're allowed to do. That's the overall lesson here. But that's the thing with authority. When you say someone can act on your behalf, be aware of how much authority you are granting them. And then finally, we have liability. Can you be held responsible for an agent's actions? Certain agents are able to enter into illegally binding agreements on your behalf. You can be held liable for the agent's conduct. Always keep in mind, if you're going to have someone work for you, if you're going to have someone go out there and operate in the world on your behalf, know whether or not you are liable for their actions. In class, we're going to go over these different examples. So please click through them, look through them again, but we're going to go through them now that we've talked about agency relationships and see if we can better guess what some of the relationships are with these different examples in creative practices. Okay, that was section 1, agency, done, easy, right? We know everything now, perfect. Oh, the spacing didn't work. Oh man, I'm terrible at markup. Okay, labor and employment. And the NPR example's not in there. Oh no. This might be an older version. I'm going to pause this and update the website. And we are back. What was What but a momentary blip for you was a few minutes for me. Sorry about that. When I had updated this lecture, it updated an older version which had some typos in it and some formatting that wasn't done. Now we're up to date. Okay, so labor and employment. Now we're going to talk about what it's like to be an employee or to employ someone, which is different than an independent contractor, which is the third section of this lecture. Third, even though I put up four fingers, third. So let's get started. Employer-employee relationship. So why do I want to talk about being an employee? Why do I think that's important? Because you need to understand the differences. Oh man, this is just not my day with formatting. All right, I'm going to pause again and fix this. Okay, and we're back again. Sorry, I'm having numbers of computer issues today. Okay, now we are back. So why are we talking about employees? Why is it important to understand this? Why do we need to understand labor and employment law in general? Here's the thing. There are a number of laws and regulations that were very hard-won rights and responsibilities that labor activists fought for. These were the things where it's like turn of the century when there were strikes and people forming unions, and it's the rights of the worker. So it's important to understand these things because employees have rights. So why is it understand why do you need to care about this? I put an example up here from NPR. So if Uber and Lyft, the ride sharing apps, here's the thing. The way that they're set up is people sign up for the app, they can be a driver and they use their own car and they drive around and work their own hours, and Lyft and Uber are all happy because it's like those people aren't their employees. They don't have to pay as much money for them and they don't have to worry about them all the time. It's like, because it's kind of high risk because you have randos getting into other randos cars and who knows, car accidents or serial killers. But what happened is that they were treating these independent contractors as such an essential part of the business that some of the drivers were like, you know what, I'd like some of that labor law. I'd like some of that to protect me. And so they brought suit, and a California judge ordered Uber and Lyft to consider all of their drivers employees, which now gives them, those former independent contractors, gives them access to labor law. So now they can collectively bargain and unionize if they so choose. And they also get employee rights, and this is what we're going to get into. So real quick, working definition of an employee. An employee, it's a person, so this is the agent. It's an agent hired to perform duties on an ongoing basis for a principal, whose work conditions and methods are strictly controlled by that principal. An employee means like it should be ongoing. There should not be a set end date for an employee. It should be an ongoing relationship until someone quits or gets fired. Ongoing versus an independent contractor. And we talked about this in the legal agreements unit. You might say like, okay, well, it's only for a term of 1 year. For an employee, it should be ongoing. And again, work conditions and methods strictly controlled by the principal. They tell you where to work, when to work, how to work, and they're supposed to provide you with everything you need to do the work. So it's one of the most common types of agency relationships. The employer, the principal, controls all aspects of the employee's job. How they're paid, at what rate, where they work. I've already said this stuff. I should, as I look into the camera, it's hard to read at the same time. So I keep mentioning these laws that govern this relationship that were, this is again only US law, and specifically I'm only covering federal law, but there are laws that govern the employer-employee relationship. And they fall into two basic categories. Labor law, which is the set of laws pertaining to a group of workers. And then there's employment law, which is the right of an individual worker. So it's essential to know these practices these laws and practices, because if you hire and manage people, you have to adhere to many of these rules and laws. But something to keep in mind is that these kind of fluctuate depending on how large your business is. So sometimes if you only have 10 people in your business, uh, you might not have to adhere to certain federal and state laws regarding things like discrimination or accessibility, um, or family and medical leave. They might not apply strictly to your business if there's only like 5 or 10 people, but if you have more than 50 people, for instance, you might have to adhere to these laws, and it changes law to law. So just keep that in mind. It depends on the size of the company, how and in what way some of these laws apply. So first, let's start with labor law and the rights of the group. So in general, labor law references the area of law that governs how a group of employees must be treated in their right to collective action. So I want you to think of like a factory, a farm, a museum, production of a film. These are all efforts of a group of people, a group of employees are needed to succeed. You have to have, it's not just an individual person here, that you need to have a whole group. Labor is group. So this is especially important, like say you work in theater, is you need to understand like this is where unions come into play. So helpful definitions: labor union, um, organization of workers formed for the purpose of advancing its members' interests in respect to wages, benefits, and working conditions. So these are a group of workers coming together to form an organization so they can collectively bargain with the employer. And look, right there is collective bargaining. Negotiations between an employer and a labor union, usually on wages, hours, and working conditions. So here are some laws to be aware of. Fair Labor Standards Act. It provides a right to the minimum wage, the right to overtime pay when exceeding a 40-hour work week, and prohibits most employment of minors. So you can see how this is kind of an important law. This is where the ideas of minimum wage and the 40-hour work week come in. Those are enshrined in labor law. If you work as an employee, basically anywhere, as an employee, a definite employee, and you work more than 40 hours per week, and you're paid an hourly wage, you can claim overtime. It gets a little bit different. It starts to get a little bit different if you're like a manager or something like that, because that's a salaried position, not based on hourly time. But the idea is like, this is that base level thing that guarantees overtime if you're an hourly worker. There's also minimum wage, which is pathetically low right now. But, those are things we need to solve after the clown gets out of office. And then also employment of minors. Obviously, you don't want to have the children doing work. It's dangerous, and they should just go play and go to school. And then the National Labor Relations Act. So this was the law in 1935 that affects, it enshrines the rights of workers to form labor unions and to do other types of organizing activities. Fun fact, you cannot be fired for wanting to organize a labor union. I'm going to say that again for the people in the back. You cannot be fired for wanting to start a labor union. You want to know how to start a union where you work? Reach out to labor activists, reach out to different unions. There are people that actively work on helping people establish unions at their place of work. Okay, so that's the group. Now let's talk about the individual, because there's a lot of things we didn't get to yet. It's like, okay, that's great. I can collectively bargain. I've got the minimum wage. Awesome. But like, what about me? What about me as the person? What about me? I'm so special. Me, 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 me. That's where we get into employment law. So this complements labor law. So as a complement to labor law, we have employment law, which defines the rights of an individual worker and job applicants. This is a whole funny one that a lot of people don't understand. Employment law, it's not just employees. They have to adhere to this for the job applicant as well. If you are applying to a job, they have to follow all of these rules as well. So for an example, discrimination is a good example. You cannot be racially discriminated in the workplace as an employee, But you can also not be racially discriminated in the job application process. So employment law generally deals with the following issues of the individual worker: discrimination, wrongful termination, wages and pay equity, taxation, harassment, right to privacy, workplace safety, whistleblower rights, which is essentially saying that if you call the company out for doing something illegal, you can't be fired for that if it is in fact something illegal. Leave policies, so if you have to leave for medical reasons, and hiring processes. It's a lot of stuff. It's really important. It's important to know employment law, and not only federal law, but also the state laws as well. There's a lot of things here to empower yourself as an employee of an organization, to look up what this stuff means, to know what your rights are. So I linked a site here, FindLaw. It's a really helpful starting point. They have a really great employment law and human resources page. They go into extreme detail on all of these aspects. You can really educate yourself on your rights here. But broadly, let's talk about some key laws to be aware of. All right, title, oh no, I don't know Roman numerals. I'm gonna say Title 9, Title 7. Who knows? Of the Civil Rights Act of 1964. This applies to employees with 15 or more employees. Discrimination, less than 15 employees, apparently it's okay. But that's what I was talking about, where there's different levels of this stuff. But it prohibits employers from discriminating in the hiring process based on race, color, religion, sex, or national origin. Actually, there's an update to this that I forgot, because there's a Supreme Court case since the last time I taught this class, which is you cannot be discriminated based on your sexual orientation anymore in hiring practices, which is great. That's not sarcastic. It's really great. I'm really happy about it. I think it was bullshit that people were ever discriminated. I think all discrimination is bullshit. Moving on. Americans with Disabilities Act defines a disability as a physical or mental impairment that substantially limits one or more major life activities. It prohibits discrimination against a person with a qualified disability. And it provides that if an individual with a disability can perform essential functions with or without reasonable accommodation, that person cannot be discriminated against on the basis of the disability. I had a student once come to me and say, I'm really worried about the job process. I don't think anyone's going to hire me because I have this nerve disorder. And I looked at her and I said, they cannot not hire you just because of the nerve disorder. That's illegal. She had no idea. If you have a qualified disability, you are protected under the Americans with Disabilities Act. You know, they cannot discriminate against you in the hiring process. They cannot discriminate against you in the job process. But it all comes down to this idea of a reasonable accommodation. So let's say, for instance, you need to take a break every couple of hours and just not look at a computer screen because of a certain neurological or disorder that you have. That's a reasonable accommodation, to be able to not look at a computer screen and take a walk. That's not a big deal. There's other things too, like needing to order like specialized furniture if you have a wheelchair. You know, being able to provide, my brain is blanking, but we're going to move on. Anyway, Americans with Disabilities Act. There's a documentary, I believe it's coming out soon, about the people that fought for the ADA to get it into law. It's a really, really fascinating story. It all kind of like originates around a specific summer camp. Age Discrimination and Employment Act prevents employers from giving preferential treatment to younger workers to the detriment of older workers. You will notice that is one direction. You can't give, like, you can give preferential treatment to older workers apparently, but it only applies to workers 40 years of age and older, and to workplaces with 20 or more employees. There's that thing again, it's depending on how many people work there. It does not prevent an employer from favoring older employees over younger employees. You want to, in the most straightforward way possible to put this, it's basically, it's so an employer can't just dump your ass because you're 60 in favor of someone who's going to be around longer. That's age discrimination. Fair Labor Standards Act provides regulations as to the duration of workdays and breaks an employer must provide. It also governs applicable salary and overtime requirements set out by the federal government. Remember, there's also going to be a level of state and local law on top of this. But this, for instance, so an employer cannot tell you that you can't go to the bathroom. I've had people tell me that they were told to sit at their desks for 8 hours and they were not allowed to go to the bathroom. That is illegal. You cannot prevent someone from going to the bathroom. Employers have to give you breaks. And there's durations of work that they can't make you work 22 hours a day every day. You know, I could go off for eons about horror stories students have told me. Know your rights. Family Medical Leave Act provides that an employer must allow employees to take up to 12-week leave of absence for qualified medical purposes. I should mention, this is 12 weeks unpaid. What medical condition could possibly be 12 weeks long that every other country virtually in the world gives paid leave for? A condition that affects a very specific gender. So this stipulates that to qualify for the leave, the employee must have worked for the employer for 12 months and 1,250 hours in 12 months preceding the leave. And it preserves qualified employees' positions for the duration of the leave. So if you go on the medical leave, they have to have the job for you when you come back. They can't just get rid of your position while you're gone if you're on this leave. Now, again, this is one of those ones, I think I forgot to put it in here. This only applies if there are 50 or more workers at this business. If you want to get even more educated on this stuff, in addition to government websites, I linked to some stuff here. Freelancers Union, WAGE, which is Working Artists in the Greater Economy, and the Precarious Workers Brigade. They all have a lot of great information on labor activism. And then a good book just to keep on your shelf is the Human Resources for the Non-HR Manager. This is the book that I had in grad school. It's just kind of a nice overview of all the things that you need to pay attention to. It just explains what human resources is. A few notes on employment ethics. In the interest of time, I encourage you to read this on your own. These are my opinions that I'm going to talk about more deeply in class, but things like inviting diverse opinions so you can have criticism, being open to criticism so you can have diverse opinions, making roles easy to find, pay equity, things like that. Okay, finally. Independent contracting and self-employment. So we've talked about labor, we've talked about the employer-employee relationship. Now we're going to talk about independent contractors, also freelancers or the self-employed, all kind of interchangeable definitions. So an independent contractor is a person hired to perform a limited specific duty for a party according to a contract for a specific period of time. Their work conditions and methods are not strictly controlled by the principal, but by the terms of the contract. I'm going to repeat that. Their work conditions and methods are not strictly controlled by the principal, but by the terms of the contract. Remember, we talked about in legal agreements, contracts are incredibly important to understand for this exact reason. So an independent contractor is not automatically an agent in their relationship to the principal. The key words here are independent, limited, and contract. The relationship is governed by the contract between the two parties and legal standards of contract law. Now, there are going to be some higher level laws on top of that. So let's say, for instance, again, I talk about real estate agents a lot because I bought a house last year. A real estate agent has to adhere to certain laws and practices set out by the federal and state governments. That helps define that relationship. But in general, your agents don't have to adhere to employment or you don't have to adhere to employment and labor law in dealing with an agent. Same thing. If you are contracting with someone, you don't get those automatic protections that employment law and labor law give you. The relationship is defined by the contract, so the contract is extremely important. Now, as a key point in understanding the difference between independent contractor and employee, It's not just whether or not a principal calls you an employee or an independent contractor. The relationship has to be defined and has to abide by set of standards set out in U.S. law. So the IRS, which surprisingly has an amazing educational resource the IRS is great. They actually have like really great simple explanations. You wouldn't think it coming from a tax organization, but they have great explanations on this stuff. I encourage you to go to the site irs.gov and read in depth about defining independent contractors versus employees. But in general, the IRS gives us 3 top level tests to determine whether someone is an employee or an independent contractor. First, behavioral. Does the company control or have the right to control what the worker does and how the worker does their job? So if a principal is supplying the office, the equipment, sets your hours, you're most likely an employee. If you operate independently of the principal and determine for yourself how the job will be completed, you are likely a contractor. I want to take a step back and emphasize, it does not matter what the person hiring you says. If they say, well, you're an independent contractor, you're not an employee, but then they treat you like an employee, you can report them and be like, they need to treat me like an employee, because there are, again, laws and protections and rights and also taxes that you wouldn't have to pay. So that's behavioral. So it's how you're treated. Financial. Are the business aspects of the worker's job controlled by the payer? These are things like how the worker is paid, when expenses are reimbursed, who provides the tools, supplies, etc. So how, when, and in what manner are you paid for a job is a major determinant factor. We're going to cover this in future finance units, but it's this idea of, so do you invoice the principal for pay? So an independent contractor, do you give them an invoice and say, here's how much it cost, $2,000, or are you on payroll? So are you paid on like a bi-weekly basis according to an hourly wage? Does the principal furnish all required tools for the job? So, I'm an employee of Carnegie Mellon University. They give me everything I need to perform my job functions. I don't have to bring my own personal equipment to work. They provide the computer, the desk, they provide the phone line, everything that I'm going to need to do my job. Or does the principal furnish just some of it? So it's like maybe they furnish the office, but I have to bring my own computer. Well, in that case, I might be more closer to an independent contractor than an employee. And then finally, the type of relationship. Are there written contracts or employee type benefits? So if you are receiving employee type benefits, you're likely an employee. An employee type benefit are things like healthcare, workers' compensation for injury, retirement plans. These are things that are additional benefits on top of your salary. If you do not receive these benefits, you're likely a contractor. Additionally, in the contract between you and the principal, they should expressly state as much. We're going to cover this more in Unit C. This is from an older lecture. We're going to cover this more in finance units. And then, will the relationship continue? And is the work performed as a key aspect of the business? This goes back to the Uber and Lyft example I talked about at the start of this lecture. So if it's an ongoing relationship and it's a key aspect of the business, you're probably an employee. And that was the argument of the drivers for Uber and Lyft. Uber and Lyft cannot operate without drivers. It's a core function of their business. And it's an ongoing relationship. You're a driver as long as you want to be until you quit or you're fired. So in that way, the drivers in California got together and were like, hey, we're being treated like employees, ongoing relationship, and we're an essential aspect of this business. We should have access to our rights as employees and as a labor group to collectively bargain, to form unions, to have protections, all these hard fought for rights. So that is why it's important to understand these things. The thing is, like, the California state government agreed with them. I don't know if that's going to go federal, but the California state government was like, yeah, you know what? You are being treated like an employee. So these companies can't call you independent contractors. They have to give you access to benefits and to these rights and all these other things. So, but like, what are some of the consequences if, like, why is it important? Like, why should you even give a shit if you're a freelancer or an employee? Well, for one thing, and we're going to cover this in finance units, independent contractors pay higher taxes. They do. You know, you could be paying as much as 25 to 30% on the money you're bringing in versus like 15% that's withheld off of your paycheck from an employer. Independent contractors do not have access to company benefit plans, health insurance, retirement plans. Like, you know, man, I have health insurance through CMU. It's great. I don't have to panic all the time, especially in a worldwide pandemic. So you don't want to get cheated out of things like health insurance. Non-salaried employees are able to claim overtime pay for over 40 hours a week. Independent contractors cannot. You can independent contract for a job and maybe you work 22-hour days for 6 days straight to get the job done. The thing is, that was your decision because you're an independent contractor. You don't get to claim overtime pay, you know, but a point of empowerment, maybe you could put that into your contract that if you're forced to work over a certain number of hours a week, there's going to be a penalty for that. But again, it's in the contract. You're not protected by labor law. And then most importantly, independent contractors do not have the protections afforded through labor and employment law. So if there's one thing I can say, or there's a couple of things I will say to wrap up this unit. One, when people represent you, they can get you into trouble and you'll be liable for them. Make sure you trust who represents you. Two, it's a really big deal. You have, when you're an employee, you have a lot of rights that come along with that. When you're an employer, you have a lot of responsibilities. And then finally, independent contracting, that relationship is defined by the contract. Make sure you're protected in the contract. You know, if you're not going to be protected by employment law, put it in the contract. You know, remember, if it's a legal agreement between both of you, they're going to have to adhere to that. So that's it for labor and representation. Next week, we're going to do something more fun, which is intellectual property. All right, see you soon.